My lords, I'll go directly to the April 2015 letter, if I may.
Yes.
This is at page 664.
Page
664. My lords, the information in this letter regarding Jamaica Beach Park's indebtedness is not new information. Mr. Finzi had it, demonstrably so, 5 months before the action, the 2005 action came on for trial in June 2012.
So they had it 5 months before?
Before the 2005 action came on for trial in June of 2012. And 8 months before, he entered into the settlement agreement in August 2012.
Can you explain the calculation in the letter to us? Because that would be the simplest way of dealing with it, if you can.
I'm going to try and do that, my lords.
This is the calculation of the amount which went into the settlement agreement, as I understand it.
Yes, it is. And, my lords, just to say, before I get there, if you could permit me, that he was under no duress at the time, because the freezing order was a 2006 freezing order, and it lasted only 9 days in 2006. So he was not under any such oppression in 2012. There was no fraud or concealment perpetrated against him. And aside from the statement in the letter itself that various of Mr. Finzi's previous counsel had received this information already, I wish to take you to page 649. And on page 649, my lords, you will see a letter dated January 25, 2012, from JRF to Winston Finzi. And this is prior to both the court action coming on for hearing and the settlement being struck. And in it you will see on the first page, second paragraph, that there's first a statement about the loans that were acquired by FinSAC from NCB on or about September 30, 1998. And that is represented by the grids on that page. And that is Unity Farms, Universal Holdings, Jamaica Beach Park US accounts, Jamaica Beach Park, Jamaican dollar account, and Winston Finzi account at the bottom. It was always JRF's position that it had received and acquired a Jamaican dollar indebtedness from FinSAC, because this is what FinSAC transferred to it. And if you look on the second page, on 650 of the same letter.
So these grids on this page 649, these are what FinSAC acquired from NCB?
Yes.
And do they correspond to that 2011 Freedom of Information Act list of loans?
The Jamaican dollar loans are not on that.
Sorry, the Jamaican dollar loans,
Loans are not on that,
on what?
on that 2011 grid received from Errol Campbell.
But here, the Jamaica Beach Park, both the US dollar and the Jamaican dollar accounts were acquired by FinSac.
Yes. And if you look on the second page now, you will see that the second paragraph, on or about January 30, 2002, Jamaican Redevelopment acquired all the above listed accounts from FinSac. Now, this statement is supported by the date on the deed of assignment.
That's the document with the list we were shown before, where we were shown the 30 million.
Yes,
Jamaican
the one which is one page of 218, yes.
Sorry, which paragraph?
So this
which
date-
paragraph are you reading from reviewing the file?
One minute.
Which paragraph are you reading? The paragraph.
I was reading the second paragraph on 650, where it says on or about 30
Right.
January 2002, JRF acquired all the above listed accounts, from FinSac. And then it goes on to recite how the debts accrued, and then it speaks about the sale of the property and the application of the net proceeds of sale following the sale of the Jamaica Beach Park security. And it says at the bottom of the page, if you look at the last 4 lines, in applying the proceeds of sale, your lordships are with me? I have first applied the proceeds to settle the Jamaican accounts, and then applied the remaining balance to the US accounts on a pro rata basis. Accordingly, after application of the proceeds in this manner, the balance on the Jamaica Beach Park loans as of September 16, 2005 were, and there at the top of page 651 is the exact same information that is contained in the April 30, 2015 letter, showing the clearing off of the Jamaican dollar indebtedness and the application of the balance to the US dollar indebtedness, thereby reducing it to a lesser sum,
That's the same information as in.
the 2015 letter.
Thank you.
So this was in Mr. Finzi's possession demonstrably, aside from having been received by his several lawyers many times before. On the material before the court on page 649, it was in Mr. Finzi's possession from at least January of 2012.
And just to repeat the last piece of the jigsaw, are the Jamaica Beach Park Jamaican dollar accounts, are they in that list attached to the assignment? The list of accounts which has the 30 million, which has the 30
Now, when you
million.
say the list attached to the assignment, there are 2 lists. There's the one received from Errol Campbell, and there's the one attached to the deed of assignment.
Yes, that's what I meant.
I think that's that. No, it's not, because that page is only dealing with the Fs, the debtors whose names start with F. Jamaica Beach Park starts with J.
Ah, I see. So that list is not the whole
No,
list of
there are
debts assigned?
218 pages. That's just one page of an appendix.
Oh, I
consisting
see.
of-
So in the
and
other,
it's a
somewhere in the other pages are these other loans?
So these are alphabeticized,
I see.
right? Now, it has always been Jamaican Redevelopment Foundation's position that it acquired those loans from FinSac, and that NCB sold them to FinSac, and they were thereafter unsold to JRF. Now, in the material that received from Errol Campbell, not only does he state categorically that, well, he apologizes for the fact that their database only captured principal balances and did not capture interest balances. He says at page 662, Unfortunately, the database did
Sorry,
not.
page 662?
662? 662.
Thank you.
The last line of that letter, that sentence, unfortunately, the database did not save interest balances at the time of the sale to JRF, and thus only principal balances have been supplied. That does not mean that only principal balances were sold to JRF. It means that they did not capture the interest balances on the loans that were sold to JRF. For what reason, only they can say. But when you look at the deed of assignment, it clearly states that what is assigned to JRF is all the seller's rights and interests and pertinent rights pursuant to the debts listed in Appendix A. And then if you turn the page at 663, you see a statement in caps at the bottom. Interest balances were not captured at the point the loans were sold to JRF. His affidavit, I believe, and I hope I'm correct in taking you to page 70. Yes. Just to show you that at paragraph 18 on page 73 of Errol Campbell's affidavit, he says that all the debts were acquired from National Commercial Bank as at September 30, 1998. The principal amounts, as detailed in the table above, were sold to JRF as at November 1, 2001. Now, that's clearly not the case. The deed of assignment shows they were assigned to JRF on the 30th of January, 2002. So that is an error.
And you say that the list was incomplete, do you?
Yes, and the statement that the principal amounts were assigned is also, well, Mr. Campbell is not a lawyer. I think he's using language loosely. It may be that a discounted amount was paid for the debts.
But that list does have some Jamaican dollar sums in it, but not the ones from Jamaica Beach Park.
No,
And you say
and not Unity Hall or Universal Holdings either, because if you look at 365, is it 365? Is it 365 where that is? Yes.
Sorry, where are we going?
At 365, I think, my lord, this is the appendix exhibit A to the deed of assignment that you were looking at, the 30 million.
Right, and that contains the account 10201.
Yes, my lady. Yes, my lady. First of all, on page 362, you see the date of the deed of assignment is the 30th of January 2002. So when you go to the source document, you see that Errol Campbell's statement is inaccurate as to the date that the document was transferred to.
Where do we see the date?
On page 362, right under the words form of assignment at the top.
Yes.
But are you saying that there are some more pages attached to the deed that we don't have?
Yeah,
and we've only got each.
If you look at the bottom, you see this is just page 18 of 281.
Right.
So, and if you look at the format of it, you see it's clearly alphabetized.
I can see that. It starts with MK Sports and it ends
right, so it starts with E and it ends with H. So you wouldn't find Universal Holdings, you wouldn't find Unity Farms, you wouldn't find Jamaica Beach Park on this source document, because this is only in relation to the Fs, which is why Mr. Finzi's name is here.
But you showed us the letter of the 25th of January 2012.
Yes.
And that has certain Jamaica Beach Park Jamaica dollar accounts,
yes,
which are not in the letter from.
And to add some kind of resonance to that, hopefully, if you look at 650 in the last 650 in the last paragraph. Where it says, please note that the Jamaican dollar accounts ending 344 and 345 were both overdraft accounts and were compounded pursuant to their terms. There's nothing novel about interest accruing on unpaid and overdue debts. So, and then it's under that now that he says, in applying the proceeds of sale, and I read that section to you for already, and that information about the overdraft accounts, one does not just pluck an overdraft account out of the air. Is in essence, you find some corroboration for it from Mr. Finzi himself on page 50 at paragraph 86.
All right, 86, page 50. I'm sorry, can you help me with the page, please?
Page 50.
That seems to be paragraphs K, L, and M.
M. So if you look at M and the last 3 lines of M, no Jamaican dollar account existed for Jamaica Beach Park as they were all consolidated into the single unsecured overdraft facility in the name of the claimant. He's not saying that the debt didn't exist. He's saying it was transferred from Jamaica Beach Park into his personal name. At least that's how I understand that statement. That's how I understand that statement. And that's Mr. Finzi's.
But I thought that
What?
those were all paid off with the proceeds of sale of Jamaica Beach Park, the Jamaica dollar accounts.
Yes.
And the US dollar accounts were partly paid off from that, but
Yes.
not wholly.
Yes, yes. And then there was a residual balance. And then the Appellant property was sold as per agreement. And at this time, if you look at 605, I believe it is. Sorry, before you go to 605, just look at is it the April 15 letter? Yes. If you look at page 668 of the accounts that are attached to the April 15 letter, April 2015, sorry, April 30, 2015, which starts at page 664.
Yeah.
If you look at the page 668, and we are looking at the summary of the account, the indebtedness now, as at the 30th of April 2012, the very last grid on that page. At the bottom,
Yep.
you see a figure of 3,761,90.
Yeah, that's the settlement amount, as I
That's the
understand.
settlement amount, and you find that amount at page 605. The court, having considered all the material, enters judgment in the sum, in that same sum of 3,761,908.4, not plucked out of the air, but supported by evidence. And the interest amount of 1,897,538.05 from May 1, 2012 to today's date. And then if you look at page
I'm sorry, 605, we were looking for the figure.
605,
3.761. Yes, I see it. Thank
you
you.
see it, Millard?
Yes.
And then just below that, there's the interest sum of 1.8 million. 20% interest on 1 million. Oh, okay. 12% interest on 1 million, 1.8 million. Right? And that ties back to the figures in the 2015 letter. So if you go back to, I'm sorry to keep flipping you back and forth, but if you go back to 668, the grid at the bottom,
Yes.
You see the 1.897538.05 under principal there? So the 3761 is principal plus interest. And then if you look on the left hand, on the, if you look on the 667, page 667, I mean, these are all considered by the courts below. If you look at 667, you see it starts with the principal sum of 1837, writing is very fine, in the grid that is turned sideways. And it ends with a legend below the grid that says, judgment pursuant to settlement endorsed on counsel's brief, 3,761,908.40 plus interest on 1897 from May 1, 2012 through July 1, 2013. Total amount 4.2 million. And that reflects the figures in the judge's order at page 605. And it also reflects the figure that is reflected in the settlement amount in paragraph 1 on page 609. And that is a settlement that was entered into on the 28th of August, 2012.
Reflected in the settlement amount at what page?
609, in paragraph 1 on page 609. And the date of that settlement is the 28th of August, 2012. So, my lords, I'm hoping that you will.
Just, sorry, just to, so that judgment was entered into in what circumstances?
I will ask Mr. Manning to address that momentarily because he was counseling all those cases below. So his knowledge of it is much more
But was
detailed than mine. But
the sale of the Avalon property to pay off that debt under the settlement agreement, was that the result of those debts being secured against that property, or was it as a result of the agreement of Mr. Finzi that it should be sold in order to pay those debts?
the latter, and also there was a unlimited guarantee of Mr. Finzi supported by, and he agreed that the property, the Avalon property, should stand as security for the Jamaica Beach Park indebtedness. Mr. Manning can take it to that too,
Okay.
in due course. So it's all documented, and was all before the court. Several points.
I don't know if this is an appropriate moment, but as we've just seen the judgment entered on the 4th of June 2012, page 605, in the sums you've shown us.
Yes.
What was causing concern this morning was the claim form in these proceedings, which is at page 449.
Which proceedings?
The proceedings which led to the judgment, which is at page 605. So that's 2005. Sorry, I mean the claim number is 5397 of 2005. And the amount claimed in the claim form is substantially more, I think, maybe I'm wrong, maybe, yes, it is substantially more than the amount of the judgment. So there's 64.8 million Jamaica dollars and just over 6 million US dollars.
Yes.
And that was contrasted with the figures of what was shown to be owned following the sale of the property in about 2005, which were much lower. So I mean, maybe you can't answer this, maybe Mr. Manning can, but it would appear as if the claimant in these proceedings has rather lowered its sights in terms of the amount that it was claiming, and it might just be helpful to have some explanation of that.
It may be, and I asked Mr. Manning to deal with that, but as her leadership pointed out, that was defended. It was the subject of a defense, which appears at page 452.
Which very much took issue with those figures.
At paragraph 3, it challenged it squarely.
It did, and I mean, are we to infer? Are we to infer from that to a considerable extent, though by no means totally, JDF agreed with the point that was being made, that actually the claim was for too much money?
That I can't answer, but I can say, because there's documentary evidence of it, that the judgment was set aside. If you look at 607, the judgment on 605 was set aside.
Ah, yes, but that was part of the settlement.
And the matter was then settled on terms endorsed on counsel's brief.
Yeah, no, I know. The point I'm making predates that. You've got a judgment for $3,760,000 US, plus interest thereafter. That's a good deal less than the amount that was claimed in the claim form. It's just the difference between those that I'm concerned to understand.
Yes, my lord. And what I'm saying, I may not be able to explain it in detail, but if you look at paragraph 4 on page 609,
sorry, right.
that same, you see that what JRF is saying is we will accept a lesser sum of 1 million.
No, but that's less than 3.7 million.
Yes.
I'm on a different point.
Okay. I'll let Mr. Manning address that. Except for me shortly, to make a short point, that these documents are all dated February of 2006.
I think your point you made earlier was that at any rate by January 2012, there was a meeting, and there's the letter you showed us that set out on page 649 the figures following that, and so that the claim had come down, as reflected in that, from the 6 million to the sums for which judgment was then entered, I think.
Yes, my lord. And then
set out in that letter, which you say is substantially the same as the explanation given later in 2015.
Yes, my lord. And then even that sum of 3.7 was further lowered, if you want to say, to 1 million, if you paid within. Well,
he had the chance to settle to get out.
If you paid,
came up with the money, but
he came up with the money quickly. Yeah, you would get the benefit, which they didn't, of course. And of course, please don't skip over paragraph 24 on page 614.
Sorry, 614?
614, in the term of the settlement agreement, whereby the defendant acknowledges that he has had the benefit of legal advice. This is not just signed by him, it's also signed by his attorneys at law. So, my lords, I don't want to take up too much more time, but I would, if you would permit me, I want to say a sentence or two about the second and third respondents. The second and third respondents are sued only in their capacity as the servants or agents of the first respondent, JRF. And to the extent that there's nothing against them personally capable of rising to fraudulent conduct or being the subject of a conspiracy or collusion of some kind, there is no legal basis for including them as defendants to the action brought against their disclosed principal, JRF. Somebody mentioned something this morning. There was a passing reference to the perjury alleged in the particulars of claim. The perjury alleged in the particulars of claim is perjury alleged against, I believe, Jonathan Goodman.
He's one of the other defendants who was never
served with the proceedings. And then you're using that as a basis to allege fraud against other defendants who are served. I don't think that's
Well, I think what matters is the allegation against the company, isn't it?
Yes, and therefore, and even in the case of the company, there is no fraud. That is, on the respondent's case. There's nothing that rises to being an actionable or cogent case of fraud, such as would warrant this to come out of the category of abuse of process and go forward to trial, with the possibility of unraveling what now in 2023 is 2 decades of wranglings, 2 decades of wranglings between Mr. Finzi and the Jamaican Redevelopment Foundation. I wanted to highlight 1 or 2 other things before I just hand over briefly to Mr. Manning Millers. The striking outs did not appear. The striking outs of these earlier actions, these were not done capriciously. They occurred after consideration by the various courts of the allegations in the context of the undisputed documentary evidence of the debts produced by GRF, which included proof of succession to the receivables, loan agreements, mortgage documentation, certificates of title, statements of account. All of those you will find at pages 277 to 376. You've already looked at the statements of account, but the mortgage documentation and so on, you will find at page 704. I really very much feel that I would like your lordships to take note of the words of Honorable Miss Justice McIntosh as she then was in one of the earlier actions, I believe the same 2004, was it the 2004 claim? Yes. Where she says at the top of the page, just under the
which
quote.
Which page, please?
704.
704, thank you.
Just after quoting from Three Rivers District Council and Bank of England, she says the following: I found this approach to be exceedingly helpful in this case, where the circumstances clearly put it within the well-recognized exceptions referred to by law.
I'm very sorry, you're reading.
You're not following.
Oh, it's at the top of the page.
704, my lord, just under the quoted words.
Yes, I got it. Yes, thank you.
I found the approach to be exceedingly helpful in this case, where the circumstances clearly put it within the well-recognized exceptions referred to by Lord Hopes, as it is clear beyond question that the defendant's statements of facts is contradicted by all the documents on which it is based. And so this is not a question of no courts having deliberated, considered, and so clear was it that the striking outs followed, not only by her, but also by the Honorable Mr. Justice Sykes, as he then was. And helpfully in Honorable Mr. Justice Sykes' judgment,
I think didn't we get sent that extra today?
No, in the record I'm speaking about, Justice Sykes' judgment in one of the earlier cases in this matter.
Page?
You find it for me? I just wanted to make the point that in his judgment, he very helpfully recites the history of the matter, 2003, 2004, 2005, and goes through all the various actions.
That may have been was that the judgment that Miss Greer-Tolland sent through this morning?
Page 501.
Oh, okay.
It starts on page 501. And it starts the recitation of the history. Starts at paragraph 17 on page 507. virtually impossible to adjudicate upon abuse of process claims without recounting the history of the matter. This case is no exception. Very helpfully, he gives you a synopsis, if you want it, of what was in the 2003 action, what was in the 2004 action, what was in the 2005 action. He did at the end say that there was no definitive finding by the court at that time, but this case that he was trying was going on parallelly, as a parallel proceeding with the one being tried by the Honourable Mrs. Justice McIntosh. So he would not then have known that she had come to a determination on there being no actionable cause of action when he was writing this. So his history, his recitation of the history, did not include the parallel case that was going on before his sister, the Honourable Miss Justice McIntosh, whose judgment I commend to you from start to finish, because it is quite insightful. So, my lords, it is a respondent's submission that this thing is an abuse of process, not just from 2017. The abuse of process has been going on for some time. But there is no miscarriage of justice here. There is nothing new. The due diligence requirement, even if it existed, would not apply because there is no new material. All the material was before the court. All the facts underlying the word fraud, which has been liberally expressed in the particulars of claim without any anchoring or particularization. If you look at the particulars in 86A to V, I think it is, which claim to be the particulars of, you see the governing words of that.
This is at page.
I think it's 47. My memory serves me correctly. Yep.
86A.
47.
47. If you look at the bottom of 47, you see the governing words of 86.
Yes, paragraph 86 is
Yes.
said.
Based on the information received from FinSAC, the following conclusions are evident. And then you have 86A to V. So all of these conclusions at A to V, every single one of them, purports to be derived from the information received from FinSAC. The only other document, as your lordships pointed out, is the document at paragraph 73 on page 43, which...
Sorry, is paragraph?
73 on page 43. The document was not named, but that is the 2015, that's the April 30, 2015 letter that reference to the without prejudice communication in paragraph 73. Your lordship had brought it to my attention that it was in fact mentioned in the particulars of claim. And the reason why it hadn't been present in the forefront of my mind.
It's also 86M, it's mentioned, isn't it?
86M. Well, maybe that is where your lordship picked it up from, because in 73, that is the document referenced in 73, paragraph 73, I believe. But it doesn't say, it doesn't identify it as a letter dated April 30, 2015. It just says, response to claimant's attorney's request and without prejudice communication was sent, without saying what was the date of it. So I didn't immediately pick that up as being a reference to the April 15. But when your lordship asked me to look for the April 15 references, I realized that this was also a reference to that. But the April 15 doesn't stand up. The information from FinSAC doesn't stand up as being a basis for fraud. And so the entire scaffolding comes down, and with it, the edifice that is being constructed upon it. So I will just ask Mr. Manning to wrap up with those few questions, if I may. Others.
My lords, you had posed a question to my learned friend about the calculations that were, or the change between the sums that were sued for in the 2005 5397 action and the eventual settlement sum, the 3.761 million that was revealed in the settlement agreement, as well as in the calculations to the April 30, 2015 correspondence. I confess, my lord, I'm going to go from recollection now that the calculations at the time in 2005, when the suit was filed, involved some compounding of the interest that did not apply when Mr. Rudd wrote in 2012, and when the matter was again revisited in terms of providing accounts in 2015. That's the best of my recollection, my lords, as to the change in the numbers, the amounts that were reflected in the claim versus what was reflected in the settlement sums, my lord, and the accounts provided.
So the claim compounded interest to a greater extent that it was then accepted.
That's my best recollection, my lady.
I just wonder if that can be right, because the amounts claimed in the 2005 claim form included 64 million Jamaican dollars.
It did, my lord.
And that, of course, doesn't feature
It does
at
not.
all
That is
later on.
That too is correct, my lords. One way to, I certainly can address it, my lords, is that certainly in 2012, and in fact, when my learned friend took you to the letter from Mr. Rudd to the appellant in 2012, perhaps what is also instructive is the context in which the letter was written, my lord. It is acknowledged by the respondent, by the appellant, that the letter was written without prejudice.
Sorry to interrupt you, but I think that, I mean, I've mentioned the Jamaican dollar figure, but of course the US dollar figure included in the claim form was for 6 million.
That's correct.
Whereas judgment was entered for 3.7 million. I mean, I think the important point from the point of view of this case is the letter in January 2012.
Yes, sir.
And if you can't give an explanation for the significant reduction in the debts A claimed and B for which judgment was entered, then the natural inference was that some rather substantial mistake had been made by your client in the claim form in 2005. I mean, would that be an unreasonable inference to draw?
My lords, I don't wish to say that that whether that inference is reasonable or unreasonable. I think, my lords, that because I am recollecting, and of course this is not something that arose in the matter in the court below.
I mean,
so I was just seeking to assist the court, and I do recollect that there was a time when there was some discussion between the parties, and this is why I've taken you to the letter at page 649, the same January 2012 letter, because I do recall that at some point there was a meeting of the parties, and the letter does speak to the fact that the parties met to renew efforts to settle the ongoing issues. And I do recall, my lords, that as part of that discussion, there was an engagement on the question of the compounding of the interest.
But it can't just be compounding.
I'm not suggesting that that is the only reason.
Because the figure has come down.
Yes, and I'm not suggesting that there's any.
Because the issue arose this morning because the accounts showed that following the sale of the property, and we've been shown some this afternoon, the Jamaican dollar account figure was nil.
Yes.
And yet, 3 months later, a claim form is being issued claiming 64 million Jamaican dollars. And that was the concern. How come this was happening?
And my lords, what I'm seeking to address you on, though, is the difference, and perhaps I misunderstood, the difference between the sum that was claimed in the suit,
yes,
and the sums reflected in the April letter, my lords, the April 30, 2015 letter.
Yes.
That's what I was seeking to address.
Yeah, but I think the point that was being made against you, my lord says, was that the April 15 letter shows what had just happened.
Yes.
And that in fact there was a balance of whatever it was, dollars owed and no Jamaican dollars. And then a few months later, the claim form comes winging in for some Jamaican dollars, which apparently didn't exist, and a much bigger US dollar sum than it seems now was actually owed.
I think, my lords, what I am addressing to you is the question of this reduction from the amount claimed in the claim form versus the calculation that was provided in 2012 and or 2015.
Yes.
That's all I'm seeking to address you,
Well,
my
that's
lords.
what we're wondering about.
Yes.
It's the same point, but another way around.
Right, and so what I'm saying is there would be a diminution or reduction if in fact there was compounding before, but not compounding that is in 2005, but not compounding when a calculation is being done in January of 2012. That's the distinction I was bringing to your lordships.
I see. It might have been recalculated.
Well, that's correct, my lords. And I'm saying it was in the context too of where the parties had met to renew an effort to settle, and that the first respondent certainly revisited the numbers. So to your point, my lord.
It may not matter in the end.
Yes.
But since quite a lot of this was made this morning,
Yes.
What we know is that in September 2005,
Yes.
the Jamaica Beach Park accounts were shown as there being a nil balance on the Jamaican dollar account, and on the dollar account, a debit of, or an amount owing, of 2,254,000.
Yes, my lord.
So to issue a claim form a month later
Yes, my
for
lord.
6 million, or 64 million Jamaican dollars,
that I don't have a response to.
and nor I think can compounding be the answer to the dollar amount, because the US dollar amount claimed, I think, was 6 million.
Yes, my lord.
So compounding can't account for a change from 2.5 million to 6 million in 1 month. So I mean,
Yes,
it's
my
just
lord.
a complete mismatch.
And if I just may just bring that to a full closure, my lord. I'm certainly not seeking to address the distinction between the September 05 figures and the sum that is in the claim forms, my lord. I was seeking to address the other side of it, but I appreciate the point your lordship is making.
Yes.
My lords.
Was the 2005-5397 particulars of claim, did that relate only to the Jamaica Beach Park dollar, Jamaica dollar and US dollar accounts?
I think so.
Yes, my lady, that is correct.
But, so where was the Finzi personal overdraft of 30 million, nearly 31 million Jamaica dollars? Which cause of action was that?
My lady, I know that is the position of the appellants, but your ladyship will recall that the $30 million that is reflected on the grid is the sum that featured in the 2004 litigation.
I see.
That was said to be the Avalon debt, my lord.
Right.
Lady.
Your client's case is that was somehow the equivalent of the 464,000 US dollars that was claimed in the Avalon.
In fact,
It's the same sum as shows in the 2012 letter, I think.
the sum
30 million Jamaican.
that was settled for the Avalon debt, my lord. And in fact, this is where I actually intended to take your lordship and your ladyship back to address some of the questions that were raised to my learned friend at the start, because there is a lot of talk about this Avalon debt as though Avalon had actually borrowed monies, my lords, when in fact that's not the case. So it's somewhat of a
debt of Mr. Finzi.
It's somewhat of a misnomer.
Yeah.
This was a loan and a debt of Mr. Finzi's, my lady. And this was a situation where Avalon itself, certainly when that money was borrowed in 1995 March, Avalon was not an entity on the record of the company's registry. It had been struck off the Cayman Company registry, and that you certainly will find in the record at page 369, the confirmation of that. So it was struck off, and I take you back to it, my lord and my lady, because this is a situation where, though it did not borrow any monies, and there was no Avalon debt, the appellant's case has been pushing the line that there was no equitable mortgage because there was no Avalon debt. But it is strictly speaking true, there's no Avalon debt because, of course, Avalon did not borrow any monies. But what we have clear before her ladyship, Mrs. Justice Norma McIntosh, as she then was the borrowing by Mr. Finzi, but using a title that Avalon itself had entered into an agreement to purchase from another party. And Avalon, my lords and my lady, in the record you will find where there is a company resolution and acknowledgement that Mr. Finzi is the beneficial party entitled to have title put in his name.
Could you help me on that? You say that the borrowing was by Mr. Finzi, but he was using?
He was using the title, that is at volume 1203, folio 671, as the security for his borrowing.
That was the Avalon property?
That's what we call the Avalon property. That's correct, my lords.
Is that the same as the Providence Estate property?
His lordship, in his written judgment, refers to it as Lot 1 Providence Estate, my lady.
And he was using the title of the Avalon, for the Avalon property as security for his own debt, and there's a company resolution that says that he's entitled to
that. He's entitled to it. Yeah. That's right, my lady. And so there would be a vain search for a mortgage or a loan in the name of Avalon. And so to hinge a claim on fraud to say that there was never an Avalon debt and it has been wrongly pursued is in fact not an accurate representation of what happened in the mid-1990s.
To be fair, it was described as the Avalon debt because it was a debt acquired, loan taken out in order to buy the Avalon property.
Oh yes, my lady, and to that extent I have no difficulty because we too refer to it as the Avalon property. Yeah. But to say there's no Avalon debt, my lady, and to suggest that there was no equitable mortgage, when the record before her ladyship McIntosh in fact showed that it was Mr. Finzi's attorneys at law, Messrs. Crafton, Miller and Co., who in fact proposed that because they could not perfect the title to put the title in Mr. Finzi's name, that they would hold the title and the instrument of transfer and await the further instructions of Mutual Security, Merchant Bank and Trust Company. That was what was proposed by them, and your lordships will see that in the record. But why I mention that, and I don't wish to belabor the point, but I think it needs clearing up, is that in the first litigation that was brought, in the first time that the parties interfaced with each other in litigation, which is claim number 2, it's in 2003, claim HCV 1858, Mr. Finzi alleged basically that it was a loan to Avalon and that he was a surety. And so this is why I have belabored the point that there was no such loan to Avalon. And could never be, since it was not an entity, certainly at the time of the loan. Mr. Finzi said it was a loan to Avalon, and then, if your lordships were to look at the third litigation where the parties interface with each other, which is the 2004 suit now, HCV 2843, that's the one where there's a written judgment of Mrs. Justice Norma McIntosh, you'll see that Mr. Finzi then says that in an amended defense, in his original defense, he said, yes, the loan was to Avalon, but in an amended defense filed, he says that, in fact, it was himself who borrowed the money and not Avalon. And also interestingly, because your lordships have asked the question earlier.
Where do we see that?
Do you have a reference? My
lords, the third suit, you will find it at page 257.
His defense.
That's the claim.
I crave your lordships. At page 257, my lord, it was the actual fixed date claim form. The defense, my lords.
I think it's 377.
Thank you, my lady.
I didn't catch it. 3.
So his original defense, my lords, he said that at paragraph 3,
There's page.
this is page 377, my lords. What he maintained at that time was that there was an arrangement or an agreement where he would guarantee a loan, balance purchase monies to Avalon to complete the purchase of lands, part of Providence Estate, 9 acres, and so on. And so that was his assertion then. And he actually, my lords, carried with this assertion further. If your lordships were to look at page 432, what you will find there is Mr. Finzi executing and filing a caveat against the same property. So page 432, my lords, there's caveat number 1348180, and this was filed, I believe, on 17th, well, it's dated, let me be more accurate, it's dated 17th of March 2005, and it's over the same Providence property, my lady, what we call the Avalon property. And what he repeats there, my lords, if you look in the box which is under the caveat number, you see it says that by agreement between Avalon Investments Limited and Mutual Security Merchant Bank and Trust Company, Winston Finzi agreed to guarantee a loan to Avalon to complete the purchase of Lot 3, part of Providence. Said loan proceeds was paid to the vendors in exchange for duplicate certificate of title engrossed in the name of Winston Finzi. And so that was his initial defense to that litigation, my lords. But then he filed an amended defense, my lords, in which, at page 390, in which he changed the landscape of the pleadings.
Sorry, page 390.
Page 390, my lords. Because in the same paragraph 3, which is now fully amended, and it's a brand new paragraph, basically, he says that, he avers that and says that he entered into an agreement, that the defendant entered into agreement with Mutual Security Merchant Bank Trust Company, whereby the bank agreed to make a loan to the defendant, that is Finzi, for the purpose of the defendant acquiring property, and that's the same Avalon property that is described there, my lords. So, yes. What later transpires, my lord, is that, and I think this is most important because I believe your lordships pressed my learned friend as to whether or not a debt arose that Mr. Finzi was responsible for, if you will. And this is important because he's now acknowledging that he borrowed the monies. And in this very amended defense and his amended counterclaim, he also denies making any payments on account. And why? I'll show you where he says so, my lords. If you look at paragraph 9 on page 392, and this is paragraph 9 of his amended defense. At paragraph 9, Mr. Finzi describes the fact that he learned that the proceeds of the loan was disbursed by the bank, and he says that he made it clear, this is the last 4 lines, and he made it clear that he would not pay interest on the said loan until the property was transferred into his name. That is his unequivocal statement that he's not paying the debt. And at paragraph 19...
His case was that he had taken out the loan personally, but there had been an agreement that it wouldn't be repaid unless and until he got the title deeds
in his
to
name.
The Avalon property in his name.
That was his assertion.
And that never happened, and he had never paid any.
It never happened, my lady. And at paragraph 19, he further affirms that he will say, this is at page 394, my lords, he will say that he paid no money to the claimant because no money is due and owing to the claimant from him for the reasons mentioned in paragraphs 3 through to 14, my lords. Why does this matter, my lords? Because, and I should perhaps just round this up for completeness, which is that it certainly was the first respondent's case at this time that Mr. Finzi had made no payments on account of this debt. So Mr. Jonathan Goodman said so, my lords, at page 258, I believe, paragraph 8 at page 258, Mr. Jonathan Goodman in his affidavit says that no payments were made by Mr. Finzi. Ms. Janet Farrow in her affidavit filed on May 17, 2005, you'll find her at page 409. If your lordships look at page 410, in paragraph 5 of that affidavit, she too says unequivocally that the defendant has never made any repayment of the said loan. And I ask you, the point I'm raising with you now is why does that matter? Is because in the particulars of claim now filed by Mr. Finzi in this suit, which is before you know the 2017 litigation, if I invite your lordships to look at page 28,
What is this?
this is in the 2017 litigation. We're looking at the particulars of claim, my lords. And I'm inviting you to look at page 28, where your lordships will find paragraphs 7 through 11 of the particulars of claim. Mr. Finzi now describes that, let me start, my lords, at paragraph 8, that the Appellant title was pledged to MSMB on March 10, 1995, through the claimant's then attorneys at law, Crafton Miller, as a primary security to secure a mortgage of $464,000. And I pause there, my lords, to say that you will see that that is at odds with his earlier assertions that he gave no mortgage. And then he continues at 9 that MSMB, in approving the special loan facility to the claimant to purchase Avalon property, accepted as collateral security a letter of undertaking from AJ Dabdoob Company to forward to them part proceeds of sales of lots by Maho Bay Company. A copy of that letter, he says, approving the arrangement is affixed and exhibited. And he continues that to the best of the claimant's information, knowledge, and belief, properties owned by his company, Maho Bay Company Limited, were duly sold on or about August 1996, which was shortly after the special loan facility was tapped by the bank. The proceeds of these sales were used to pay down the special loan facility. And then finally, my lord, he says that the claimant was in dealings with a prospective purchaser of Avalon and wished to ensure the title was free and clear of all encumbrances. The claimant drew down on the JBP line of credit and paid out the special loan facility in full. This was during the transitional period of MSMB being acquired by a national commercial bank. Neither MSMB nor NCB registered any mortgage on the certificate of title for Avalon, as the special loan facility had come to an end. And I pause there, my lords, to say, your lordships would, when you look at the amended defense and counterclaim that was filed in 2005, and this that is now being asserted in 2017, somewhat 12 years later, none of these particulars were raised by Mr. Finzi as a part of his defense to the claim for the equitable mortgage in the 2004 litigation. None of these particulars were mentioned by Mr. Finzi. The importance of that point, my lords, is this. This is not information that I have recited to you that is coming from any information gleaned from Errol Campbell and FinSAC in 2011. And there is certainly no suggestion here, my lords, of any other conduct on the part of the first respondent or its agents that prevented Mr. Finzi from putting forward this as his defense. This is their classic seeking to take a second, if I may use the colloquialism, bite at the cherry by Mr. Finzi. But it is cloaked, my lords, with the assertion that a fraud has been perpetrated on the court and on him by the first respondent, when there's nothing here that is pleaded, my lords, that suggests that the first respondent has any knowledge of the facts set out in paragraphs 7 through to 11 of the particulars of claim.
Can I just clarify, paragraph 15 on page 29?
Yes, my lady.
I'm not quite clear about the relationship between the overdraft of the 3980 million Jamaican dollars and the two sets of Jamaica Beach Park accounts, some in Jamaican dollars, which were all then paid off when the Jamaica Beach Park property was sold, and the US ones were substantially reduced, although not entirely paid off. Because it looks there as if the remainder of those, or, well, I'm not quite sure what the timing of this is, but perhaps you can explain what is being said in paragraph 15 there on page 29.
Well, my lady, of course, this is the appellant's pleading, but I certainly will see if I can assist the court, my lady. He has said here that interest rates skyrocketed, and the claimant, he says, fell into default, and the bank extended to him a personal unsecured overdraft facility of Jamaican 30.98 million, which was the facility used to consolidate the Jamaican dollar JBP interest accounts, and further was a single facility used for all interest accruing on the JBP US dollar drawdowns. I certainly understood. I certainly say to your lady that I sought to understand it myself in terms of what was being proposed by my learned friends. I know, my lady, that from the first respondent's point of view,
Yes.
this sum of Jamaican $30 million was defined, if you will, as the indebtedness that arose from the loan that was used to secure the purchase of the Appellant property. That much we are clear on, my lady.
Well, what is it that connects it with that loan? That's what I found a bit confusing.
Yes,
because it's 464, it's a US dollar loan of 464,000 US dollars, I think. And then there pops up in the assignment schedule, the line which has a reference to Finzi and 30 million Jamaican dollars. But what's to say that those two have any connection with each other?
Indeed, my lords. And this is the point I'm making now, in fact, which is that the assertion that he's making now is that they had no connections with each other. At the time, it's funny because this is the one litigation that I had no involvement in fact, and I'm tasked with the response to your lordships. But this, as I understood from the evidence that was put forward by Jonathan Goodman, was that we have the security in hand, we have an unlimited guarantee as well for Mr. Finzi. That unlimited guarantee.
Well, let's not confuse things with that. Let's
very well, lady. So we have this in hand. We have the deposit of the titles in hand, and we have the correspondence from between Messrs. Crafton Miller, Mutual Security Merchant Trust Bank, and Messrs. Clinton Hart, who I believe were acting for the vendors at the time. And they put, my lords, that information before her ladyship to say that this is the debt that we have for Mr. Finzi.
But those letters just refer to the 464, I think. There's nothing that connects them with this sum.
Well, what is interesting too, my lords, is that the judgment itself, which appears at page 687, this is now the judgment of Her Ladyship Mackintosh, at page 687 of the record, Her Ladyship had an application before her for an order for judgment to be entered that calculated the monies that were due to the first respondent based on the actual loan amount of the US $464,472.52 and interest on that sum, as opposed to the Jamaican dollar figure that was in the schedule that your lordship has referenced. So that what we do know, my lords, is that ultimately, in terms of a calculation and in terms of what was found, there was, if you want to say, it was played down the line in terms of the amount that was on the correspondence as being due in terms of the loans that were made to Mr. Finzi and in terms of the interest at the 16% rate that I believe it was, 16% per annum, from the day that the deposit of the titles was made, rather the disbursement of the sums of money, the 10th of March 1995, up until the date of judgment, my lords. So that ultimately, even if, my lords, there is an argument to be made that the 30 million doesn't correlate one-on-one based on exchange rates and so on at the time, what does correlate certainly is the supporting correspondence as it related to how much money was borrowed and the application of the interest rates, my lord, to that sum of money.
But as far as you're concerned, you dispute this paragraph 15 because you say that the overdraft facility of the 30-odd million Jamaican dollars had got nothing to do with the Jamaica Beach Park.
Yes, madam.
Those are entirely separate.
That is his assertion now today.
Yeah, right. And you say those are separate and those were the subject of the 2005 5397 claim, which was for a lot of money. In fact, it turns out it was for too much money. It was then cut down and you got the judgment for that, and then that judgment was set aside, and that's the settlement.
That is the Jamaica Beach Park portion of it. That's what happened eventually. Right. Yes, madam.
Yes. So that's all the Jamaica Beach Park, and the 30 million
Appellant
is connected somehow with the 464 US dollars, but we're not quite clear how.
And even if it is not, what is clear is that there was an indebtedness, my lady, and certainly what we can be sure of, and this is why I took you there, is we can have confidence that this is not a claim that has been made twice, because Mr. Finzi himself says, I refuse to pay because I didn't have title.
Yeah, well, we just want to see how it was assigned.
Yes.
But in the assignment schedule, actually, the US dollar equivalent to the 30 million Jamaicas is there 653 US thousand, which in 2002, which seems broadly consistent with 682 3 years later, maybe.
And what,
that's on page 365.
And certainly what would have been helpful, my lords, is that the response that Mr. Finzi is giving now in 2017 certainly would have been helpful for the court to have in 2005. Although we do note that even with these new allegations of his, my lords, he does not put before the court any material to support it. So it is still just a bare allegation that he too is making, that there's this arrangement and that this was how it was done and so on, my lords. When 12 years ago, 12 years before that, he was saying, I actually chose not to pay because I didn't have title. So he blows hot and cold, not just here, but he does it in several other occasions, my lord.
Well, I take all those points. I mean, I was just concerned to see whether in your case, the evidence that you put in the 2004 did show in some way that the 30 million did have some correspondence with the 454 and wasn't a completely separate document.
Yes, my lord.
Because if you follow through the correspondence with Mr. Finzi and the lawyers and all that, it's all referring to dollar sums of 454, I think.
464.
Yeah,
My Lord,
54, yeah.
My Lords, if I may also just add, I was taking you to Her Ladyship McIntosh's judgment, which is at page 687. Her Ladyship, I should indicate that from this judgment, there was initially an appeal filed by Mr. Finzi, which he withdrew, and we do know that he did actually settle the judgment sum as well, my Lords. But Her Ladyship did make the comment that, which is as much true today as it was then. At the top of page 699, Her Ladyship said, in my view, it was not a matter of drawing conclusions as to what the agreement was. The claimant produced documentary evidence as to the terms of the agreement, and the defendant offered no real challenge to those documents. I say it as much true as it today as it is at that time, my Lords. Then she says at page 702, this is at the last paragraph there, my Lords. As I see it, only the bank would have grounds to complain about the outcome of that transaction, as it did not end with a first legal mortgage in favor of which the bank had every right to expect. He really has no cause for complaint, as he is the party holding up the process. In effect, he's claiming that since the title is not in his name, he has no obligation to pay a loan, which he's today saying he has, and which he has obtained to complete the purchase of the land, and which resulted in the completion of the purchase with the certificate of title available to him to effect transfer into his name. As long as he does not do what he should do, then the claimant is not entitled to payment of interest, nor it seems even to repayment of the principal. I know of no principle of law which would allow this or any defendant to be unjustly enriched, as would be the result in circumstances where the bank's funds assisted in the acquisition of property while the loan remained unpaid for over 10 years. So that is what the court grappled with before coming to the conclusion that, in fact, not only did the defendant and his representative control the position as to his registration as transferee of the property, but it would not be open to them to challenge that there was not an equitable mortgage arising in the circumstances. I spent time on that, my lords, because the Avalon property is the property that we know is the substratum now of the settlement agreement in 2012. Even though the settlement agreement concerns the debt for Jamaica Beach Park, what we had in May of 2006, my lords, before the Honorable Mr. Justice Sykes, was a consent order reached between the parties that the property, this what we call the Avalon property, would stand as security for the eventual outcome of litigation between the parties that was then ongoing. At that time, 2 suits were in train. That was a 2005 suit, 5063 of 2005, and the 5397 suit of 2005. The first one was settled, and that was for a small sum of money. I know he has complained that he doesn't know what became of the $50 million, but the record does show that that suit was settled and $50 million was applied to the debt for Universal Holdings Limited in that suit. And my lords, the proof of that certainly is at page 654 of your lordship's bundle. Page 654, your lordships will see a letter from Nunes, Kofi, Deland and Co. to Capital and Credit, I think it's Merchant Bank. And again, at page 637, there is the check for the $50 million that was paid by the bank. And at page 648, the joint notice of discontinuance, which says that it's discontinued because the matter is in fact settled. That's at page 648. So we know what became of the $50 million that he says he doesn't know what has happened or no accounting has been given for it. It was settled. And so we come now to the big one, if you will, which is the last sort of controversy now that is existing between the parties. And this is why I think the importance of upholding a settlement is significant, because there is, on his case, that he has obtained information from FinSAC in August of 2011, and he also has obtained information from Jamaican Redevelopment Foundation prior to that, but certainly we can consider the January 25, 2012 letter as well as information. So he can weigh his position, and he has a pending litigation, my lords, at that same time too. So as at January of 2012, he has available three things to assess. He has the FinSAC information of August 2011. He has the first respondent's letter of January 25, 2012, setting out the accounts from the perspective of the first respondent. And he has the existing litigation, which is set down for trial some 6 months from that date of January 2012. That is the 5397 litigation. Those three things are what he has to weigh. There is no change by him. There are no amendments made by him to the existing litigation to reflect the matters that he raises now today in his particulars of claim. He does not, my lords, in response to the assertions of the first respondent in its letter of January 25, 2012, he does not respond to say, stop for a moment, look at this. I have this that I have received from my inquiries of a public body, the FinSAC, that says something very different from what you say, that you have these debts assigned to you. Doesn't do that either. And as it relates to the existing litigation, he doesn't then tap into the existing. You remember, my lord, that in the existing litigation, he has said that there is excess or an overreaching by Jamaican Redevelopment Foundation. He has said so in his pleading, in his defense and counterclaim, and he's asking for an accounting in the 5397 litigation. So you would certainly know that the information that he has received is relevant, and that he would be expected, or his attorneys certainly, to deploy it to their advantage by making it available in terms of whether it is a supplemental witness statement, whether it is an amendment to his pleadings and the like. Instead, my lords, and I heard your lordships ask the question about what led to the sanction in June, on June, was it 4, I believe, what led to the sanction, my lords, and I confess, my lords, it's one of the things of the litigation. It's been some years now. I do not recall what he was in breach of, my lords, at the time, but suffice to say, my lords, that it perhaps is not that relevant, because we moved past the sanction to the point where on August 28, Mr. Finzi, again represented by counsel, and still with the landscape being, my lords, what I set out to have been the case in January of 2012, Mr. Finzi enters into a settlement agreement. Now, my lords, I can't, and neither can your lordships, of course, read the mind of the parties and what caused them to act in ways that they did. One could ask the question, what caused the first respondent to agree to the potential that a lesser sum would have been paid by Mr. Finzi and not the greater sum? One could look to Mr. Finzi to ask the question, well, why would he roll the dice and not simply go full tilt into
The answers to that presumably lie in privileged material as between him and his legal advisors.
and certainly, my lady. But what we do know, my lady, is that having come through that crucible of analyzing the landscape that existed for both sides, both parties came to a position where they found common ground. They found common ground in 24 paragraphs, my lords, that set out how they would then govern themselves as it related to this one last controversy that they had. And I think, my lords, what you're looking for, especially now with this application, is what would cause a court to interfere with what the parties themselves clearly came to, with full knowledge of what they were doing. Indeed, the party who had more fulsome knowledge of what was happening was Mr. Finzi, because the first respondent, certainly there's no evidence that the first respondent was apprised of the correspondence of August 9, 2011. So Mr. Finzi certainly had at his disposal more information. One thing he also had, my lords, is what he said as to what caused him to go for information under the Access for Information Act. He had what he says is an audit. My lords, there is nowhere in any of the several litigation between the parties any submission by Mr. Finzi of any accounting on his side of payments he has made or any audit exercise that he has performed. So even here, where he has spoken to the fact that he has an audit that he did and that prompted him to then go to get information from FinSAC, none of the courts below and not your lordships have access to this material. But he says he had that, and he had information from FinSAC, and he entered into a settlement arrangement. And so, my lords, just to wrap this final up, what your lordships have is a situation where you expect that the party who is trying now to unseat and unravel that all of this that has happened, all these series of litigation and settlements, would put before you, before the tribunal, cogent evidence, cogent, credible evidence that would cause you to overturn not one, not two, not three, but several settlements and written judgments of the courts, the Jamaican courts. I make bold to say, my lords, that I humbly submit that you be slow to interfere with the discretion that has been exercised by the courts, in courts below. It may be that the reasoning may not have been solid, my lord, if that is your position, but the outcome, my lord, cannot be any different. That this appellant has not put before you the material that can make you feel that this is the kind of case that requires a court to feel uncertain, that would cause a court to feel uncertain of what transpired below in terms of the outcome, and would give this litigant another opportunity to present his case, such as paragraphs 7 through 11 and other assertions that he has made. That, my lords, in a nutshell, is our position, and we say there has been no substantial or any, actually, miscarriage of justice. And if that is so, and your lordships feel confident that that is so as well, then we certainly ask that your lordships dismiss this appeal.
Thank you.
Unless I can assist you any further, my lords.
I think so. Thank you very much, Mr. Manning. We're grateful. Lord Gifford. Mr. Toland.
May so please the board. The first issue which I wish to address in response is which concerns the Avalon debt. At page 277 of the bundle shows a collateral security, which says a letter of undertaking to be obtained from A.J. Dabdoob and Company Attorneys at Law to forward us part proceeds of the sale of lots by Mahobe Company Limited. This will correlate, as your lordships have noted, to what we assert in our particulars of claim, the fact that the lands were in fact sold, and so the collateral security was realized here.
Which land?
This is the Mahobe Company Limited. This was another set of lands which Mr. Finzi had disposed of. And in so disposing, a part of the agreement was that there would have been, the proceeds would have been transferred to the bank so that the bank could have that as a security for the loan. Now, I know my friend, the respondents, have made heavy weather about the fact that we appear to have asserted that there is some Avalon company debt which has somehow arisen. But we want to make clear, by way of clarification to the board, that it is not the hope that there would have been an Avalon debt evidence on Exhibit A to the deed of assignment. At all material times, if there were a loan for the 464, it would have been in the name of Winston Finzi, because it was a loan taken by Mr. Finzi to purchase the Avalon land, and that is why we have conveniently termed it the Avalon debt. Mm-hmm. Now, I would submit that there has not been a satisfactory explanation of the correlation between the 30 million and the 464.
That doesn't matter, because that was all the 2004 claim, and there was judgment. That judgment has been satisfied, as I understand.
Indeed, it was
by
satisfied.
The sale of some other property.
No, in fact, the judgment was satisfied by payments of actual checks in satisfaction. So shortly after the judgment sum was given for 1.3 odd million, that exact judgment was satisfied. So the reference to an unlimited guarantee was an unlimited guarantee which arose as a result of the loan transactions, but not one which would have been satisfied. So there would have been no need for the guarantee.
Sorry, I'm sorry. Which guarantee are we talking about?
With the loan agreement, this is a loan agreement at the time in 1995.
Sorry. Is this the loan of page 277?
This is the loan of page 277.
Well, there's no guarantee there, is there?
No, there is a promissory note.
No, there's a letter of undertaking, which is the basis of the equitable mortgage, I think. And there's also a registered mortgage.
Yes. So the unlimited guarantee to which my friend refers is a guarantee for Mr. Finzi as it relates to that loan.
But it was a loan to Mr. Finzi.
Indeed.
So who provided the guarantee?
Which provided a guarantee at that time.
By whom?
The guarantee was provided by, and I crave your indulgence. Yes, the guarantee was provided by Mr. Finzi.
But it's in relation to the debt. Sorry, it's a loan to Mr. Finzi.
It's a loan to Mr. Finzi. So it was just a guarantee that regardless of anything, Mr. Finzi would be liable for everything concerning this particular loan.
He is liable because he's the borrower.
Well, indeed. And what I say is that the guarantee...
And he said at the time that he never paid the money back, and he never did, and he had summary judgment against him, and that's it, isn't it? If nothing's happened since to add to what was known then.
In fact, that's not the case, and I will ask your lordships if you could. There was a judgment that was supplied by Justice Sykes. It was a judgment of Justice Sykes, which we had relayed to the board. It does not form part of our bundle, which we do have the hard copies.
So I'm not sure what you're talking about at the moment.
There was a judgment of Justice Sykes that was emailed prior, No, it does
We
not.
got that by email this morning.
Yes,
Oh, right.
yes.
Sorry.
I do have hard copies if the
We
board.
have got it on, I think it's been put on our thing.
But is this right, that this loan at 277, that is the 464
Yes,
US dollar loan, it was secured against the property, but in fact that security was not needed because after judgment on that loan, it was simply paid by check?
yes. So the only reason why Avalon continued to be a security was because of agreements made by Mr. Finzi by way of the consent agreement. Otherwise, there would have been no ability for Avalon to continue to remain as a security for any loan.
For, in particular for the Jamaica
In particular
Beach
for the
Park
Jamaica Beach Park loans.
loans, which were the subject of the 2005 5397.
Indeed, indeed, indeed. The judgment of Justice Sykes,
Is this the one you want, which was sent through this morning?
it is in fact so, my lord.
I'm not sure where that is.
It is referenced at claim number 2008, HCV 5029.
Yes, I see.
And it was a judgment made on April 8, 2009 in a matter concerning the respondent and seeking specific directions of the court.
What is this?
This was an application which was made by JRF themselves and which was argued by counsel for the respondents who are here today. JRF had made an application to the court for an order seeking to have the court sanction their compliance with a disclosure order made in the United States of America. In that application, JRF was ensuring that they would not be deemed liable for breaches under the Banking Act and the Financial Institutions Act, and grounded their application by stating at page 2 of the judgment that JRF, not being a bank, is not subject to the provisions of the Banking Act, and JRF, not being a financial institution, is not subject to the provisions of the Financial Institutions Act. We bring this judgment to your attention, most importantly for the findings at paragraph 3 to 5 and 25 to 28 of the judgment.
So this is, I hope I've got the right judgment. So this is not a judgment to which your client was a party.
It was not. So this is a this
Why is
concern.
this coming in by way of reply? What is this a reply to?
It is
What point raised by the respondents does this deal with?
My friends refer to the deed of assignment, which they attempted to persuade the board was an assignment of over 200 and odd pages long.
Okay, right. So
And
it deals
this
with that.
particular judgment specifically addresses the deed of assignment.
Okay.
And that is how we bring it to your
So
attention.
whereabouts do we look?
Yes, page, you're looking at paragraphs 3 to 5?
Well, paragraph 3 begins JRF as a company incorporated.
Indeed, indeed.
Okay, fine.
JRF is a company incorporated
Okay,
in the
got it.
state of Texas. In the United States of America, it is an overseas company. At paragraph 4, it is a debt collector. In pursuance of this business, it purchased debts owed to Jamaican financial institutions by many and varied borrowers. It will be recalled that long before the current world crisis, and it explains, I won't read it specifically, but I ask your lordship and ladyship to so do. After taking over the institutions, the debt was removed from them and then sold as debt-free institutions to private interests such as JRF, who wished to invest in them. JRF took some of this debt by assignment. This was done by deed of assignment dated January 30, 2002, which your lordship will note is the exact deed of assignment. Between Financial Institutions Limited, Workers Savings and Loan Bank, and Reefing Trust, together called the sellers and JRF the purchaser. In the case of Workers Savings and Loan Bank, the debt were sold directly. Now we don't have any of that features in this case. But otherwise, the debts were acquired through FinSAC and their related subsidiaries. JRF's rights and obligations, I now ask the court to look at paragraph 25, which features on page 8 of the judgment. The court found that JRF's rights and obligations on an assignment are to be found in the contract unless statute imposes further obligations. Now, it went on to deal with the Banking Act and Financial Act do not purport to affect the nature of the contract between licenses, but I don't think that that is necessarily relevant. What is important is paragraph 27. The other point which is vital.
Just let us get there.
Yes.
Paragraph 27.
The other point which is vital is that the provisions of the Banking Act and Financial Institutions Act apply only to their licensees operating under those statutes. JRF is not operating by virtue of any license granted by the relevant authorities. JRF is not purporting to stand in the place of licensed institutions in relation to those institutions' debtors. It has not taken over any of these institutions. It is not an independent contractor retained by any of the financial institutions or bank, and by virtue of that capacity has access to bank records. JRF holds no office in relation to bank. It is not an official of the bank. In paragraph 28, in this particular case, the deed of assignment states that the seller, as beneficial owner, hereby assigns to the purchaser all of the seller's rights, title, and interest in, and all the assets described exhibited A, attached hereto, and all interest and other monies, if any, now due and subsequently to become due in respect of such assets, to hold same unto the purchaser absolutely. If I could just stop at this point, it is in fact the same provisions in the deed of assignment. I have not seen the agreement for sale and purchase of assets, but what is clear from the deed is that only the rights, title, and interest of the sellers that is transferred. The sellers being Finsac in this case. I stand before the board today.
So what's this got to do with this litigation?
The deed of assignment, which is the hinge upon which JRF has acted.
Mm-hmm. Well, we've got that. We've seen the deed anyway. All this is saying is that, as I read it, is that JRF didn't take over the institutions or come under some responsibility. They were simply assignees of the debts.
Particular debts.
Yes. Well, that's all they've ever claimed to be in this case. In these cases.
Indeed, particular assignees of particular debts, which can only arise from an Exhibit A, which would be the Exhibit A to the deed of assignment.
Fine.
His counsel has said that in relation to the Avalon debt, we only see one particular page, which is in relation to the Jamaica Beach Park debts and any other debts, we have never seen an Exhibit A or any.
Well, you may or may not, I don't know, but
what is it?
You could have asked for it at any time during the litigation.
Well, what we unearthed from the disclosure from Finsac is at page 663 is that Finsac explicitly said that what they had provided to us was an extract from Exhibit A.
Which page is that, sorry?
663, milady.
So,
and I speak specifically with reference to the second table as it appears on it, where it says debt sold to Jamaica Development Foundation.
I'm sorry, which page are you on?
663.
663, sorry, mistake.
Mm-hmm.
Right.
Debt sold to Jamaica Redevelopment Foundation as at November 1, 2001, but they were transferred as at January 30,
You're
2000.
663?
663, my lord.
Well, the date's wrong for a start, isn't it?
Well, it might be a difference between the date of the sale and the date of the transfer.
Oh, yes, it might. It does say transfer 30th of January 2002. Yes.
Indeed,
Yeah.
indeed. And it right below that says that this is an extract from Exhibit A.
Right.
I say that to say that the best evidence before the court in all of these proceedings has been that of, well, certainly in relation to the 2017 proceeding, has been that of Finzi, who was the only person who could speak to what has been sold to the respondent, and for which they have so provided that they have extracted from Exhibit A, which my friend relies on, the particular debts which touch and concern the appellant and any of its related entities.
But that was received several months before the meeting in January, which led to the letter at 649,
Indeed.
which refers to other Jamaica Park, Jamaica dollar debts. And if there was any discrepancy, which on the face of it there is, it was presumably explored by Mr. Finzi's lawyers in the discussions.
Indeed, and I am grateful for your lordship taking us there, because that is exactly where I'm going. In the 2012 letter, which your lordship so rightly refers, is at page 649, that letter accounted for monies from the $6 million sale of the Jamaica Beach Park land, otherwise known as the Maho Bay lands. The distinction between that and the 2015 one is that the 2015 one actually gave the statement of account from the sale of the Avalon lands. Secondly, another important distinction to be made between the 2012 and 2015 letter is that you will note that 6 U.S. accounts.
I'm sorry.
Six United States.
You'll have to just start again.
Yes.
Okay, let's just back up. Page 649. Now, I'm on 649. Just repeat the points you're making.
On page 649, evidence is a 2012 letter.
Yes, indeed.
And as a matter of completeness, the 2015 letter is found at 664.
Right, but your point is that this letter at the 2012 letter at 649 shows a number of Jamaica dollar accounts in the name of Jamaica Beach Park, which do not feature on the FinSac grid in 2011 at 663, because that only lists US dollar accounts.
Well, indeed, but I think the greater point I wish to convey to the board is that we could not have acted on the 2012 letter and the 2015 letter with what would have provided us with the state of a comprehensive state of the affairs of the debts that were alleged to have been owed by the appellant. And for that reason, I wish to distinguish between the two in the hope that the board can understand why the 2012 letter would not have assisted us greatly in making an allegation as to fraud.
So what are the points of distinction?
Points of distinction.
You identified 2, but just repeat them, please.
Yes.
Indeed. The 2012 letter accounts for only the sale of the Jamaica Beach Park.
Sorry, for only?
It accounts for only the sale of the Jamaica Beach Park property.
Only the
Sale?
sale.
The sale of the Jamaica Beach Park
Well, that's
property.
the only sale that had taken place.
At the time, indeed. Whereas the 2015 one accounts for all of the sales, including the sale in Avalon.
When was the Avalon sale?
The Avalon sale was in 2015.
So,
All right, but your client had, in 2015, oh, I see, the later sale. Well, of course, because Avalon property hadn't been sold when the settlement took
But
place.
there are other areas of distinction I just wish to bring to the board. The distinctions first, before I make conclusions upon which I would ask the court to accept. And I understand the time limitations, my lord.
That's the first point of distinction. Second
Right.
point.
The second point of distinction is that in the 2012 letter, it spoke of 6 United States denominated accounts for Jamaica Beach Park and 6 Jamaican dollar accounts for Jamaica Beach Park. The 2015 letter spoke of 5 US accounts for Jamaica Beach Park and 5 Jamaican accounts for Jamaica Beach Park.
But there are only 5 listed in the 2012 letter.
No, in fact, there are 6, my lord, if I may. There was no account number listed, but the ones that did not have an account number, they were listed as loans which were still outstanding.
The 10882.
You mean there's $10,000 that doesn't have an account number?
Yes, and $3,340, which we have seen when compounded can.
Can you just, I'm sorry,
Yes.
where do I'm sorry to be so slow about this, but where do I see the $6 US and 6 Jamaican dollar accounts for Jamaica Park, Beach Park?
If the court looks at page 649
Yes, in that table.
in that table,
So those are the balances that were acquired by Finzac. They were not the
right?
acquisitions by the respondents here.
So
So that tells us what Finzac acquired.
well, this asserts
that's right.
what they say FinSac acquired. This letter in 2012 is what they asserted FinSac acquired, from which they then were assigned same.
Well, not necessarily.
No, if you look over the page, all their accounting on page 650 is just dealing with the 5 accounts
Yeah.
and 5 Jamaica dollar accounts, which I think are exactly the same ones as appear later in 2015.
So those small unnumbered accounts, I think, disappear.
Yes.
So those, I mean, perhaps not surprisingly, they disappear given their amounts, but they do. I mean, we don't know anything about them. It does admittedly say, now, hold on, it does say, to be fair, it does say on or about January the 30th, this is on page 650, JRF acquired all of the above listed accounts from Finzac.
Indeed.
So it does say that.
Indeed.
But it seems that they maybe were paid off, because it's talking then prior to the application of the proceeds, the balances.
What the 2012 letter at 649 indicates is that these were the loans at the time of the acquisition
All
by
right.
FinSac.
They do say they acquired all of those accounts, you're quite right.
Indeed.
But they're not very large amounts, are they, the ones that have been left out?
If they've been left out, it's to your benefit.
Well, my lord, I don't readily accept that they have been left out, only because the total figures at the bottom of both 2,023,000 and 68 and 36 million are both contained as a total amount on page 650 at the top.
Okay.
The reality is you've got very detailed information before your client entered into the settlement. He could have asked for more if he didn't have what he wanted. And if there are some minor discrepancies between this and something provided 3 years later, it comes nowhere near to justifying an allegation of fraud.
Well, what we received in the 2015, which we did not receive any at all in 2012, were actual accounting. And the accounting that we received in 2012 were for accounts numbered 1020259. In fact, we received no accounts in the 2012 letter. We received.
Well, you should have asked for them and said, I won't settle without seeing more detail then.
Indeed, my lord.
That's what you wanted to do.
We had been asking for them through the court process.
Fine.
And we were stymied from getting those accounts.
Now, how does any of this come anywhere close to justifying putting forward a case of fraud now?
Well, what we unearthed from the accounting in the 2015 accounts that were given were the challenges we assert that we discovered as it relates to the interest, the compounding of the interest, and also armed with the 2011 documentation and now these 2015 accounts, it would have allowed us to make an assessment of both against what FinSac said that they had not sold to JRF by virtue of them not being on the list. So these accounting, which were the 6 of 10 accounts, were accounting that we were receiving now.
So are you still asserting, based on, I think it's 663, or what you got from FinSac, are you still asserting that you can rely on that to say that actually JRF never got the Jamaica Beach Park accounts?
Certainly,
Right.
certainly.
And that is the basis for you saying they were therefore wrong to use the proceeds of sale of the Avalon property to settle those accounts and not the US dollar ones which they had acquired.
Indeed.
Right.
Indeed. And what the 2015, the bridge that the 2015 letter allowed us to do was by virtue of the accounting of the 6 accounts, we were able to definitively assess how the monies were applied, in what way they were applied, how the interest was calculated and compounded, and eventually how the application of the Jamaica Beach Park Jamaican dollar loans featured in light of what we had, what was revealed to us from FinSac.
Right, but your difficulty is that it's clear from the top of page 651 already in 2012 that they had already used the sale proceeds of the Jamaica Beach Park property to
Pay off the Jamaican dollar
Jamaica
account.
dollar accounts, and then you found out, you say, in 2011, that they had never acquired them.
We already knew that when you turned up for the meeting,
Yeah.
and presumably raised the discrepancy and were satisfied with the answer.
I would hate to say, my lord, I don't wish to say that we were satisfied with the answer. I understand the concept.
Well, chose to settle on the basis, having been told whatever the answer was given.
And I think in rounding up the point, my lord, is we asked the court to consider what Takar has said at paragraph 61, which can be found at page 1032. And the court at that point sought to define what they meant by new evidence or fresh evidence.
Well, you're going to have to close now in a minute or two.
Indeed, my lord, I'm at my final point. The court defined new evidence or fresh evidence to mean evidence that was not deployed in the actions which led to the imputed judgment, not just evidence that had come to light since the judgment. My friend has made heavy weather about the fact that none of these information were new, and these are information that we had all along. What Takar has explained is that new evidence or fresh evidence, it's not just the evidence that has come to light since the judgment. And I believe that that is an interesting point, because though we assert that the appellant, having been faced with all that he was being faced with by virtue of how the JRF went to enforce the debts and the actions that they took, which were draconian in nature, we assert that if the respondent does not have a debt, they cannot rely on the fact that there are loan documents at large, because they did not acquire such debts from the bank. And we ask the court to, in finality, to consider the enormity of the sums which the JRF has recovered from the appellant. And though we don't ask the court in these proceedings to make a finding that there has been any fraud, we ask the court to find that there is a prima facie case of fraud, and that at the time when information was revealed to Mr. Finzi, he had not taken a deliberate decision not to investigate them. but the complexity of the fraud did not allow him to just willy-nilly plead fraud at that stage, and it would have required a very detailed examination if it so pleases the court.
Thank you. We're very grateful to all counsel for your submissions. We're also very grateful to those sitting behind you who've prepared the papers for the hearing today. The board will take time to consider the advice which it will tender to His Majesty.